It's a very good morning to you, our viewers, witnesses, just live here on zimai.com. This week marks the end of Luke Malaba, the Chief Justice's tenure, literally his tenure. We are in the last 4 days, and there is no escape for Luke Malaba, writes Marie Matutu, joining us live right now. Right, Vamatutu Mamukase. Why do you insist that there is no escape for Luke Malaba?
Well, there's a lot of things that I can say that is not going to escape. But today I was just responding to an application that was made by one Mr. Musa Kika. I mean, he wrote a very nice application that is applying before High Court in order for a declaratory to say that Malaba must resign. He must retire at his midnight of 15 May. So, I mean, I wouldn't want to preempt what he has said, but the point is the law and the constitution is so clear that he cannot extend or benefit whatever the constitution amendments has said, whether I'm in agreement with it or I'm not in agreement. That is not the point. But the point is section 328, subsection 7 of the constitution says, whenever there is a bill that seeks to amend the tenure of the incumbents, the people that are in office cannot benefit. So in this instance, the bill or the amendment that was made sought to extend the tenure of Chief Justice Malaba. So in actual fact, he cannot benefit when we are reading with section 328. And section 328 on its own was also amended. So in actual fact, as section 328 subsection 7 stands, Malaba must go. That is what it means. Even irrespective of the amendments, whether somebody is saying that the amendment is legitimate or illegitimate. But the point is, Malaba cannot benefit from that amendment.
Okay, from that amendment number 2, yeah. I also saw Alex Magaisa did a piece to that effect as well. When was it? At the weekend. Also talked about that this amendment cannot benefit any of these current judges or something like that to that effect. I probably need to pull up that what do they call it? But the BSR. Yes. Okay. Yes. So you're saying here he is in a fix. He is trapped. There is no way out.
Yeah, there's no way out. In any case, we are not arguing here about the amendments, whether the amendments are legitimate or are illegitimate, legal or unlegal. That is not the point. The point is, let us assume that with that amendment existing, the point is that amendment, whether it is legal or illegal, cannot extend Malaba or any of the judges that are in office today staying. They cannot benefit out of it. They are not beneficiary of the extension. They must retire at 70, no matter what. Some other people who are going to come and occupy those offices may, if that is the case, that the amendment has been approved, may come and benefit, but not the ones that are in offices as we speak.
Right. Okay. Let me get this right. Let me get this right here. There is no way that Luke Malaba can benefit from this. We've got people tuning in here, some from Cape Town. Well, Manage Kanyoka, Audrey, Makua Pasi over there. Yeah, you're saying, Mamatutu here, there is no way Luke Malaba or any of the other judges can benefit from this.
Yes. If you read section 2, subsection 1 of the Constitution, that is so elaborate and so clear that anybody must realize that you don't need a court order to say a thing Constitution is unlawful. Whether we have a court order or we don't have a court order, the mere fact that something is contrary to the constitution. It's not in the constitution, or it's against the constitution. That person, that thing, and that action, that law is null and void without even going to the court. It's null and void. It's non-existent. If Malaba tries to stay in office after 15 May, that action is null and void. It's not. It does not even count on law.
Right. Okay. So let's be clear here. What remedies are there? How possible is it now for there to be, because I'm thinking here, this man that we call Mnangagwa, many times we've seen here, like from the time of the coup in 2017. In fact, if you go back to 2008, he tends to always bulldoze his way. Anoshandisa chisimba, he is barbaric. He breaks the constitution, his own laws. So how do we get out of this? I'm asking what hope is there now? What hope is there now to unbundling this control that Mnangagwa has continued to have? Like in this case, if he wants Malaba to stay, perhaps he could use, I know this sounds far-fetched, he could use any tool that he could get from the institutions, the state institutions, to just cause Malaba to stay in power. What hope is there right now? Okay, let me start with Mnangagwa himself. What hope does he have to make his wishes come true?
Oh, okay, let me stress this, Mr.
On a scale of 1 to 10, what hope does he have kuti iye aite kuti zvaari kuda kuita izvi zviitike, in your view?
Before I give a scale, let me just give a general background. The general background is that for almost 33 years up to 2013, the people of Zimbabwe have been living with a longest house constitution, such that when people are talking about constitution and their knowledge of constitution, they always refer to the activities of that longest house constitution. Where there is a big change from that one, people, they don't realize, like you were saying, in 2008 he bulldozed. Yes, he had the ability to bulldoze in sorry?
Yes, please go ahead.
Yes, he had the opportunity, because the largest house constitution had a citizen that was above other citizens. That was it. We had the president that was the first citizen. The current constitution does not allow a citizen that is above the others. The current constitution has got citizens that have got equal rights. The previous constitution, that is the longest house, although it has three arms of the state, but it did not explain as to where does the legislative authority come from, where does the judicial authority comes from. It did not specify where does the executive authority comes from. It just says there shall be an executive authority, armed of state, and da. It does not explain where does it originate. Now, in this instance, the current situation is we now have got a constitution where citizens have got a right and duties. The previous constitution did not have citizens that had rights. If you go and read section 6 of the previous constitution, where they had citizenship, we didn't have citizens that have got rights above the constitution or duties above the section 35 that we now have got citizens that have got the rights and the duties to uphold and defend the constitution. Even somebody is going to violate it. Now, is the onus is on us, because the onus comes in this way. If you don't act, people would presume that you have accepted a thing. Where now you are saying Mnangagwa is going to appoint somebody and do this and do those, and we remain silent and we don't act. That silence on its own is presumed as accepting. Like you are saying in this instance, where people were cooperating, when we managed to go and remove Mugabe, we were cooperating. We also wanted it. When the impeachment exercise was happening, we cooperated. We did all the things in cooperation with what was happening. So in actual fact, somebody would say we were accepting, we were behind the issue. But in this instance, if he appoints a judge, or if he says Malaba must continue, it depends now what we are going to do. Are we going to remain silent? Or we are going to come up and say, no, it cannot. Because the judicial authority, as is stated in section 162 of the Constitution, is derived from the people. It cannot come from the president, because the president was never vested with any judicial authority. He does not have any judicial authority. Neither is the legislature vested with any judicial authority. They cannot confer judicial authority. The judicial authority has to come from the people of Zimbabwe. But now if the people of Zimbabwe fold arms and relax and accept an imposter, that folding and relaxing is part of accepting. So it's no longer about blaming Mnangagwa or blaming this one. It's about blaming ourselves. Because if we fold our arms and accept an illegality to happen, then whom do you blame? That is why I'm saying, in terms of the law, in terms of what is existing, we don't need Mnangagwa to beat us or to assault us or to do what. We just need to say, no, it's unacceptable. We are not going to accept this. This one must go. That's all. That's all what we have to say. We don't even need to fight and have muscles or demonstrations or what. Just to say that, no, you cannot. Like in this instance, this guy has taken the case to the court. It's acceptable that he takes it to the court. But that's not the only provision that we are having. We have got other provisions that we can use right to the parliament. Section 149. Say the same. He cannot go past the mandate that we gave. He cannot do that. That's all. Malaba should go, and he would go. If he is not going, he is receiving a favor. And somebody who is working on a favor cannot give judiciary justice. He cannot give somebody justice. He's skewed to the people that is given in favor. It's an obvious thing.
There's someone who published a piece at the weekend, and that stated that even if this amendment was passed, okay, even considering that it was passed into law, Malaba cannot be judged, because when you are in that office, you need to be accepted by the people. And if the people have rejected, like in this case, it is very clear that the people rejected this amendment. And that is a public record. So, yeah, so Malaba cannot be, he can't even get to that seat or that appointment that Mnangagwa here wants to give him.
Yeah, you see, there are two things that we must stress. There is elements of the bill itself that Mnangagwa wants to use. Its legitimacy is something else that is so debatable, and I believe there are lawyers that are also behind it. But there is another issue that we are talking about: Malaba's tenure. Malaba's tenure does not rely on the bill. It's somebody who wants to make it rely on the bill. Malaba's tenure relies on his reaching 70 years. That's all. It has nothing to do with the bill. If somebody wants to bring the bill into the discussion or into the context, he must support with facts. And from the Constitution, it is clear that whether the bill has amended and extended the term for judges that are there, it cannot extend the judges that are in office, because there is a clear section that writes that section 328 subsection 7 says that the judges that are in office cannot benefit from there. And who is in office is Malaba. Who must not benefit is Malaba. So whether the bill is there or is not there, in any case, we are saying Malaba must, because if you read section 181 subsection 1, it says, subsection 1 paragraph A, it says, on reaching 70, he must. I mean, when you are saying must, you are not giving an option. If it had said may, then we could be saying there's an option of staying over and above that. But it says must. So in any case, he must go. He must go. There's no option.
He must.
Mm. That is what the Constitution says, and that is a thing that he knew right from the time that he was appointed as a judge, not only as a chief justice, but from the moment he was appointed as a judge, he knew by reaching 70 he must retire. So he cannot all of a sudden in 4 days to go change mind and say he cannot. In any case, the reason why he has been quiet and silent and not giving power or suggesting that there should be somebody to come and take over, it shows that he's working in cohorts with the politicians, because he was anticipating that the bill must come and vindicate him or take him to some other place. And that sign alone is not good for us. Any progressive person must challenge that and say, how can you be silent when you knew that you must retire at 70? You never even announced that you are retiring and you want somebody to come and just like what Chijausiku did. He never did that. He's silent up to today, 4 days to go. He has never even announced that he's going. Who is he intending to leave at the post? Because it's showing that he is the one that is behind this action that is being done by the legislators. And we cannot accept that connivance of the legislature and the connivance of the executive to parachute an illegal action and have somebody in office without our authority. And in actual fact, by this wording of the amendment, it says without public interviews. You cannot exclude us from judge appointment. That is impossible. We are not second-class citizens like it used to be in the longest house constitution, where the president was the first citizen and we were not first citizen. Currently, we are equal citizens. We cannot be excluded from any activity, and he cannot take any other status of being a first citizen besides that. It's not in the constitution. He has not that prerogative at all.
Well, we are now getting to the 15th of May, and so far, in your estimation on other things, okay? Because I know you have been helping the people to understand the countdown in a big way, but of course, from this corner of the legals, okay, of what is happening, what is being unraveled here in favor of the masses. In your estimation so far, outside the Malaba case, okay, outside this Malaba case, I know you've got such passion over this one. Could you update us so far here on other things that you are seeing, okay, that have happened so far? Tirimu countdown, and we are getting to the 15th of May. Akamira say, and I've got people typing in there. And the Simbama sports are papi. Update us.
Ma sports Simba ari paviri patatu. But ese ma sports edu akanangana nyangu iwo vanga vari kutovhunduka. Ma sports, I can say the sports are on two centers now. Challenging the bill. That is the amendments that have been happening, that has to be challenged. The other spot is that the mere fact that these judges of the courts that have been sued by one Mr. Musa Kika have been divided, because once we have been challenged as they are, there are some that know that they are not going to be appointed as judges of the Supreme Court or judges of the Constitutional Court. They are not going to benefit. And there are some that wish they are going to benefit. So there's going to be a division among themselves. And that division is good for us, because they are not going to, all of them, they are not going to assent to some other activities. They cannot all say, let Paddington Garwe benefit and me not benefit, or let this one obviously, all the Supreme Court judges are going to stand divided. Then the other point that is going to happen is this. If the courts do not have a chief justice, do not have a deputy chief justice, do not have judges of the Constitutional Court, Obviously, by the end of 15 May, all of them, not only High Court, not only Supreme Court, but even the Constitutional Court, will be improperly constituted. So that is a fact. So actually, the judges all the judges must be scared of this thing that is happening. If they are not scared of what is going to happen, then they are not also concerned about their own fate. The lawyers, all the lawyers, if you know, by nature, lawyers, they survive by going to courts, representing people, filing papers and all those. The legal practitioners, if they are not cooperating on this issue, definitely they are going to be attending to issues that are illegitimate. They are going to be going to courts that are illegitimate. So they must also be cooperating in this issue that we are talking about, because they are part and parcel of the beneficiaries. Whether Mnangagwa likes it or not, there is one thing that is going to happen once a court application like the one that Musa Kinka is applied, it becomes a document that has to be attended. You cannot ignore it. And that document has got declarations that people cannot now sit in court and you think that like politicians, politicians talk of Dexter Nduna. He knows that he never won elections in Chegutu West, but he's still putting on a face to sit in parliament. But a judge cannot do that. You cannot be a judge that way a face and say, I'm going to preside over a case when your legitimacy, your existence in that court is challenged. You cannot wear that face and do that unless they are also going to be politicians like anybody. So this challenge that I'm talking about is going to shake almost all sectors. We are also going to see the pretenders of human rights defenders, the lawyers that pretend to represent people. We are going to see them. If they are by Monday, they are going to attend those courts that are not properly constituted. We will challenge them and say, what type of lawyers are you? What type of constitution are you representing? Where are you coming from? Because once the constitutional provisions have been violated, they don't need to be two, they don't need to be three. One section of the constitution, if it is violated, then the constitution is corrupted. Like in this instance, we know the composition of a high court. A high court is composed in terms of section 170. A Supreme Court is composed in terms of 168. A constitutional court is composed of in terms of section 166. All those ones are provided for, and they say on top they must include a chief justice, a deputy chief justice, and without a deputy chief justice and the chief justice, they are improperly constituted. So, like I was saying to you when I was talking to the application of Mr. Musa Hika, where he was suggesting in his relief number 5 and 6 that Elizabeth Baunza must act as the Chief Justice and Paddington Garwe must act as the Deputy Chief Justice. No, that is where I was saying now to Mr. Kika, you cannot do that, because you cannot have other issues so explained and become so clear that the constitution has been violated, but pretend that Elizabeth Baunza is a deputy chief justice. She is not a deputy chief justice. We know. How do we know that? We know that she was appointed in March 2018 using the amendment number 1. She never entered any interview for that post. And we know that bill number 1 on 31st March 2020, it was declared unconstitutional. So by that means, it means she's not constitutionally appointed. She's not a deputy chief justice. And I mean, we go further and say, it means she's still a judge of the Supreme Court by appointment. Now, if you look at section 181, subsection 1, which he wanted to use as the basis of taking over the appointment or a vacant of chief justice, you read the section, it is clear that the only post that one can act using section 181, subsection 1, the only post that is vacant to be acted for is the chief justice. And only an appointed deputy chief justice can act as chief justice in the absence of the chief justice. Or in the absence of Chief Justice and Deputy Chief Justice, only a senior constitutional court judge can act as Chief Justice, not as Deputy Chief Justice. There's no provision where we have got an acting Deputy Chief Justice. There's no in the Constitution. So Paddington Garwe cannot act as Deputy Chief Justice. There's no that provision in the Constitution. Secondly, the provision in the Constitution is so clear that only a judge of the Constitutional Court can act as a Chief Justice. And by nature, we can see that Elizabeth Bounza and Paddington Garwe are not judges of the Constitutional Court, but they are judges of the Supreme Court. So they cannot act as judges of the Constitutional Court. Even if Malaba is chosen to make them, appoint them as acting without authority from anybody or from the Constitution, there's no provision that a judge of the Supreme Court can act as judge of the Constitutional. There's no such because we can read from section 177 that a judge of the Constitutional Court must be one that has got sound knowledge of constitutional law. Nobody has proven that Paddington Garwe or Gwaunza or Bharat Patel or Makarao or Koro have got those qualities of judges of the constitutional. They've never been proven before any court that they can be judges of the constitutional court. Their merit is challenged. We are even challenging some of their decisions that they are doing because it proves that they don't have that sound knowledge of the constitutional court, of the constitutional law. So now we cannot have Mr. Kika applying that Gwaunza act as deputy chief justice. On what grounds? She cannot, because that is an illegality. Her appointment is an illegality. That is also known, because we know it has been challenged, and the court found out that the bill that was used to appoint it was unconstitutional. So she cannot.
Wow, this is. Do you know what? I'm actually seeing the article, an update from the Zimbabwe Human Rights Forum right now, just last night, and I don't know how I missed this. You know, this is very bad. It was around 8:41 p.m. I must have been extremely tired, and what they're saying here. Let me just pull it up so that people can see. It is spotted in my level. It is. It's really clear, it's really loud and clear. Do you know? Yeah, you know, people like some of us, we're not into these things, issues, and we don't really understand. And we need people like yourself and others to come here, you know, go to here and there, you know, so that we're absolutely clear as to what's going on there. And the Zimbabwe Human Rights Forum literally took the outgoing Chief Justice, Luke Malaba, to court. And let me just put it up so that we all understand. Okay, so if you check in the on Zimai right now, there's an article that is titled "Court Challenge: Chief Justice Malaba cannot continue beyond 20 May 2021." Hear me. Then you will get the gist of what Vamatutu is talking about here. Okay, let me just pull it up so that people can see, and I'll put it in the timeline here. Those who are legally trained, please do help us as well. If you oppose this, also we need to hear your views. Hear me, you will help us in a big massive way to get to the bottom of what is what, even if you are not for the actual motion here, the court application. So let me pull it up so that we all see. And the link, as I'm speaking right now, is on Zimai, and we also have it on Twitter. And if you don't mind, for I don't think it will take me 1 minute. I've put it there in the timeline. Okay, so people can read it. You've got the link there. Right, click the link that you've got there in the timeline. We'll click a link, you'll be able to go straight.
You've got the link there. Right, click the link.
Okay, so click that link. Okay, so now I'm gonna read it straight away now. So the Zimbabwe Human Rights NGO Forum has filed an urgent application seeking an order for Chief Justice Luke Malaba to resign by 15 May 2021. According to the order sought, any action taken by Malaba after midnight on 15 May should be deemed null and void. The application is based on the legal grounds that the recent amendments to the Constitution cannot benefit Chief Justice Malaba. Section 328 of the Constitution that deals with tenure of judges cannot be amended without a referendum. It is also the fault of the second respondent, Chief Justice Malaba, who by now should have proceeded to leave to allow for a smooth handover and takeover. There was such a smooth handover and takeover when his predecessor left office. There has been no movement from second respondent, from the second respondent's end, even before the bill was signed into law. The impression created is that he had waited for the bill to be signed into law. Thank you, colleagues, for your continued support. So that's it there. That is from the Zimbabwe Human Rights Organization, the Zimbabwe Human Rights Forum, NGO Forum. Here we go. So we're hearing it for ourselves there. Taisa link up to those who want to read and help us. Mongoti dudzirao there. Please do so. Give us your feedback. Panaro pokana nazo erezis. As they say. Timbonza uti panano pokana nazo erapa kuti Malaba uri kuenda musi wa 15.
Inini pa ndaiverenga hangu ndikiri yose. I read this the whole thing. That is where now I was saying that relief that is sought is quite correct to the point where Malaba is being discussed. But the only part that I was saying, that is relief number 5 and 6. That's where I was now saying, no, you cannot change your goalpost and say if you want Malaba to go because of APC in the law, but you also want to uphold the tenure or the appointment of Elizabeth Baunda as acting or as a deputy chief justice, when we know that her appointment was done before 31st March 2020, where the bill that was used to declare as the deputy chief justice was later on declared unconstitutional. You cannot do that. We must realize that by mere fact that the court declared that the bill number 1 is unconstitutional, it means from that moment Elizabeth Gonza was not deputy chief justice. She was not.
Okay. And which date is this, by the way? Repeat that, please.
Let me start. Elizabeth Gonza was appointed deputy chief justice in March 2018. In 2018, that is the point. That is the moment when bill number 1 was being used. I remember they passed the bill number 1 in 2017 into law and gazetted it and used that bill to appoint Elizabeth Baunza as a deputy chief justice. But now that bill was challenged by Innocent Gonese and this other lady, Jessima Jome. They challenged it. And on 31st March 2020, the Constitutional Court ruled that the bill number 1 was unconstitutional, such that they took it back to the Senate for the Senate to go and debate about it and vote about it. Whether the actions of the Senate or what came to give any other result, that's not the point. The point is by the mere fact that the bill was not constitutional, it means whoever benefited or was appointed using the same bill. So there were some other judges that were appointed into Supreme Court without interviews. There's that Elizabeth Gwanza, who was appointed as a Deputy Chief Justice using the basis of that bill as a law. Then when the moment that bill was declared unconstitutional, it means her appointment was also unconstitutional. So she is not a Deputy Chief Justice.
Right. There's a point here, Yambotaurwa. I've got but the judge who's going to hear the matter will dismiss the application. Remember, these judges are appointed by the same ZANU-PF.
Yeah, that is you know, when people are speculating, sometimes this 2020 to 21 has created an impression that judges can just throw away things. Why? Because there's been a lot of deception that was happening. Some of the people that we saw going to courts thinking that they are opposing ZANU-PF actually were going in favor of ZANU-PF when they appeared before the court. They don't say facts. But in this instance, the whole application, if you read the application of Mr. Kick, there's no way the judge can now just ignore that. What is his explanation in throwing away that court? And in any case, remember, he's applying to the High Court. If you see the trick that this guy has done, he's applying to the High Court. When you're applying to the High Court, you have got a leeward side, a way to go and appeal to a constitutional court. Do you see that trick now? Now, when you have sued all the judges that sit in the Supreme Court, all the judges that sit in the High Court, in the Constitutional Court, but you still have got a card, a joker card, to go and appeal in a Constitutional Court, then it means some other people that are Constitutional Court judges must come and hear that court cases on appeal, not them, because those are also part of their respondents. So it's a tricky that thing that they cannot hide. Even if that judge of High Court judges against, you must remember that the person that is applying has got a right to appeal to a constitutional court against that. And when you're saying a constitutional court, Malaba, you will not be the judge in the constitutional court, or neither or any of those ones will be the judges of the constitutional court. Some other judges must come and hear that case, and those judges will not be the judges that we have inside the court. And that is proper. And the right to a fair trial is not, it cannot be limited by any law. Section 180, Section 86, subsection 3 says that there's no law that can be put to limit a right to a fair trial. So if people they don't see this coming, I don't know how they would see it, because obviously this guy was very strategic in the sense that he sued them individually. All the judges that have got the potential to come and hear that case, they are respondents.
Oh, akabhava suwa.
Yes, they are sued as respondents individually. Yes, so if you read from his application, from respondent number 1 to respondent number, I think 19, they are all judges. Individually, name by name, all the judges of the Constitutional Court, all the judges of the Supreme Court, they are specifically named name by name sued. So those judges become respondents when the matter is going for appeal or for some other reason.
Yes,
they cannot be judges. Somebody or some other judges must come and hear the matter. So we are not scared. In that case, we are not scared if the High Court judges So that is why I'm saying is he has put those judges to test. Because now this High Court judge, if he is going to rule against this case, what is only inviting, he's inviting other judges from other countries to come and preside over this.
Right.
And you know, when the other judges are coming from other countries, it's going to be a very tough thing for them to hide about it. There's going to be a very big challenge. So this High Court judge is bound to follow. He has no option. He has to follow the rule and do proper judgment and do proper things. Otherwise, he's only inviting other judges from somewhere to come and hear this matter.
Wow. Yeah,
so if you have the application in your hand, you could see all what I'm saying is. He was very strategic, and if they don't realize it, that strategic is holding them by mouth. If you see a bull, no matter how big the bull is, if you hold it by the nose, you can drag it to anywhere you want. There's no resistance at all. That is why I'm quite confident that Malaba has no option. He will go.
Yeah, this is
because while they can hide behind the scenes and try to do politics, politics you can do it openly in the political forum. But when it comes to judges, they cannot do it like they used to do, because the judicial authority is derived from the people and vested on the courts. The executive is not supposed to be intermingle or say anything like what they did during the Mugabe era, where they removed the judges, Justice Gabe and the like. That era, it was possible because the president was a first citizen and the rest were not first citizen. But not now. You cannot. Where do you draw the power? Where does he get the power? It's quite different.
Wow, here we are, our viewers, witnesses. Hey! I don't know if you're listening to this. This is quite news. A lot of Zimbabweans don't read the news. Follow news. They don't follow this stuff. Am I wrong?
Yeah, you are right. You know what?
This detail. This detail. They should be party. I mean, there should have been a whole part. Should have been partying online. Party one May over this.
Yeah. Sometimes we even if we are to blame the people, the issue is the way the regime is oriented people is. It's only in Zimbabwe where you find people are proud to be number one. If you go to a school that is there in Maheri, in the rural areas, the child is proud to be number one in class. Even when all of them, they have no shoes, the marks that she's getting are far much below what normally is supposed to be. Is only proud to be number one. And if you go into a class there in our rural areas or everywhere you go, you find that there will be a prefect, a head boy, a class monitor. All those children, they are all representing the interests of the teacher, and they are spying on each other. That issue, we are brought up into that situation where everybody is brought up as a spy. We are not there to promote each other, and if you look on the media, where we talk about, most of the people is either they are taking gossip in order to say, if you heard what so and so is saying, not for the benefit of them, what can we do, but in order to blackmail that person or to spy on that person. There's no discussion about what can we do to benefit from the idea. Like in this instance, we are talking of Mr. Musa Kika. He's brought an application, whether he has missed some other point like I'm doing them. Instead of pulling him down, I must support him and say, no, you must close this gap, you must do this so that we help each other. But going to the media, it's either those who benefit, they are relaxed, they say, Musa will just do the things, and if there's a mistake, they don't care. Or if you find the ones that are in support of Mnangagwa, they are always discouraging the spirit of the people. They are not even giving you room to discuss about this. So that is the society that we are having. At the end of the day, when we fall as a nation, we fall as a generation, we fall as a region, because even in these other countries that view these things happening, They don't realize how their economies have been affected, because Zimbabweans are all over the region now. They are taking the infrastructure to a stage that they cannot contain, just because they don't want to solve the problem. They think it's a Zimbabwean problem. They need to solve it on its own, on their own. That's the problem.
Well, here we are, obvious witnesses. What are you seeing here? Zimbabweans. I think we should come back here. I know we usually do a 7 p.m., but I think once we have opportunity during the afternoon, we should just have an impromptu session where we still discuss about this, because we are aware that a lot of our people might not be tuned in right now, because Zimbabweans, they generally, I think right now, maybe they're probably working and the like. But I just want to say, if you can press the share button, let this discussion go into my forums, Akawanda. The summary to this is that a groundbreaking lawsuit has been slapped. So it's a dead end. It's literally a dead end for Luke Malaba, as a groundbreaking lawsuit that's beyond Zimbabwean judges has been launched. And this lawsuit means that Malaba has not even 5 centimeters space to maneuver. He has to go, because the only other way this can be done is bringing in foreign judges. And the matter is beyond. So in terms of influence here, something far, a miracle would have to happen here. Miracle or some serious big manipulation, okay? Would have to be chimwe chivanu ndanati miracle panapa, but chivanu chaicho proper would have to be done. Serious criminality would have to be done here to evade this justice. So press the share button. Let's get this discussion into my forums. Let's talk about it in WhatsApp groups and the like. Let's go on Twitter as well, and let's tweet the hashtag. What is the hashtag, by the way? Let me see. There's a hashtag there. There's one that Namatai used yesterday. Let me see it.
Stop constitutional butchering.
Oh yes, there's that one. There's another one, Yakan's good trouble, okay? But I think that was yesterday. I think that's to do with politics. But the correct one is by Zim Rights, the right hashtag. Let me just get to it. It states here, let me get it. The right hashtag that they were using yesterday, from last week, is stop dictatorship or something. Yes, hashtag resist dictatorship. Hashtag resist dictatorship.
Yeah, I saw that.
Absolutely. So hashtag resist dictatorship. Resist dictatorship. Okay. So here we are, viewers, witnesses. Jump on zimai.com. Hear me. This is what we are discussing right now. And a groundbreaking lawsuit in this month of May, Gorerino 2021, Gorerema Sports. Rakazara Mawan. We have here this development in which the Zim Rights organization has sued the outgoing Chief Justice Luke Malaba, and he has to go by the 15th of May. So that is literally in 4 days from now. Literally from 4 days. Right, he has to go. So the hashtag is resist dictatorship. I'm putting it up right now to those who are tuned in. If you click onto it, you'll be able to go in and we continue to discuss this, our viewers, witnesses. Throughout the day, we will be on this. So do continue filing as much as you can. The hashtag is resist dictatorship. Right. Yes, man. Other people are typing it right now. Resist dictatorship. And we have been given details here, further details on this topic that are clear. I mean, look, these are the clearest legal pointers to where people are and what's waiting for the people of our country. I'm just noticing here, per resist dictatorship, per Twitter, even Musi Maimane just posted 4 days ago. Wow. Awesome. Well, Mama Tutu, thank you very much. I don't want to take time on, but thank you for being on this and helping us, guiding us into this. Let's continue discussing this. Our viewers, readers, and listeners. Panapa petition was signed by 8,200 people. Is this not a sign that a lot of Zimbabweans are not online? It's shocking, isn't it? The petition that was opened by Zim Rights last week has only been signed by 8,000 people. It means that a lot of Zimbabweans are not schooled into the opportunity that is there right now. It's either that or people are just not online. But this is a cause. There's a cause here for you to get bundles, buy bundles, especially for the next few days. We're going to be having these sessions, and we have been talking since last week. How far will Mnangagwa go? How far does he think he'll go? And you've got the caricature there. Right. Mama Tutu, thank you so much. Look forward to having you. By the way, 7 p.m. we'll be back here, our viewers, witnesses, but midday we will be back again on this topic because we would like many of our people, many in the nation, to know about this. Mama Tutu, thank you. And I look forward to more. Thank you. And here we are, viewers, witnesses. We're gonna just give you a few seconds as you're pressing the share button. Press the share button there to just put the hashtag, share this live, put it into WhatsApp forums, put it into on Twitter. Hear me. If you go on the website on Zimai right now, there's an article that has been published that's titled "Dead End for Malaba is Groundbreaking Lawsuit That's Beyond Zim Judges is Launched." Okay. And let me just put it up here so that you see. Let me put it up so that we see in the link here. Press this link, share it around here, and don't forget to type "resist dictatorship." Don't forget to type the hashtag "resist dictatorship." This is an opportunity, a big, huge opportunity. Sports I say it jokingly, but literally. Right. Someone is typing there, live legal ammunition. Yeah. Do you know, but we're dealing with illegality here. Illegality needs to be dealt with. But quickly, I put the link there, type it in there, and let's share it around. This is our country. These are our people. These are our kids, our great grandkids. Do you know, if you die tomorrow, what type of a country are you going to say that you have left? In what state? And you haven't played a part. What are you gonna say? Huh? So press the share button here. Let's get to. By the way, this is the countdown. This is part of our series here. Session here countdown. My sports arikuputika ega. Right, here we go. Don't forget to press the share. This is the countdown. We'll be back today at 7 p.m. But our viewers, readers, and listeners, we will have another session midday today. And by the way, have you pressed the share button? Have you pressed the share button? Well, press the share button. You gotta press it. You gotta get your kids, get everyone around there, get on Wargumamusha. And those who can record my chops, take chops out of this session and take it out into the rural areas there. Let the people know about it. Let the people know what's going on. This is our country. We're gonna move my sports. It's 21. Sarah.